Good, thank you. So it is April 2nd. This is Senate Government Operations. And we were scheduled to meet at 1 o'clock. I am right? Okay, so we're looking at the Montpelier Charter, and then we have John Odom with us, and I think Dan Richardson is going to join us. I don't see him yet, but so I guess until we'll hear from him when he comes. Did you hear back from him, Gail? I guess I'm not sure. Maybe she doesn't hear me. But John,
she hears you. The button is supposed to give me an unmute and it didn't. So,
okay.
Yes, we did hear back from him when I sent the invitation. I haven't heard back from him today, but my understanding is that he will be joining us.
Okay. So, Tucker, if you want to, we had a little bit on this before, but if you want to give us any details, remind us where we are, because it's been some time since we looked at this issue, and then we'll go to John and Dan.
Sure. The high-level overview is that the Montpelier Charter would establish a system of city voting for non-citizen residents of the city. This would permit for city issues and city candidates, non-citizens, to vote on a ballot prepared by the city clerk according to procedures adopted by the city clerk. And the city clerk would also be obligated to keep a separate checklist for these city voters. One issue that I highlighted late in the discussion last time, as I was walking you through it, was that I noticed that inadvertently the authorizing section in A1 limited city voters to the non-citizen legal residents of the city. So I prepared an amendment based on the request of the committee to add a clause that states expressly that you can vote in city elections if you are a United States citizen or a non-citizen legal resident of the city.
That would create an interesting conundrum, wouldn't it?
It would have created an interesting conundrum, and it was just one of those situations where the definition of legal resident of the city was narrowly focused on ensuring that it was non-citizens who were permanent or indefinite residents of the United States, and didn't go as far as making sure that United States citizens were also included.
Good, thank you. And you gave us that amendment, so.
Yes, and it is posted on the committee's information page for today.
Have you seen that, John? You're muted.
Muted.
Rookie mistake. I haven't looked at it yet. I just, I understand that it's there. Yeah.
Okay. All right.
Dan
So I just have one question, and this might be answered in there. Can non-citizen residents currently run for an office, or because you have to be a voter in order to run for the office? So this would, by not stating it directly, but just allow them to also run for an office in a city position.
Yes, the right to vote and the right to hold office under the Vermont Constitution and our statutes are unified. So by granting the right to vote in these city elections, non-citizens would also be permitted to run for city offices.
That's what I thought. So do we have any questions or anything right now for John or Tucker?
Actually, I have a sort of a random one, kind of. I was thinking about this last night, what else you can do. It shows you what kind of life we have, that we think about these things at night. But so if somebody comes in to register to vote, John, to city hall or wherever, they're going to have to say, hi, I want to register to vote and I'm a non-citizen. I mean, how are you going to know? Obviously, it's just up to them to say so. I mean, have you thought about that at all?
I mean, it's going to be the same system when somebody indicates that they are a citizen on the form. They're giving us an oath on a form to which perjury attaches theoretically. So it's basically the same, just the mirror as any old form. You say.
But they're not going to. Are they going to say on a form or something? Don't get me wrong. I'm not trying to be a pain. I'm just trying to visualize how this would happen. So the form doesn't say I'm a non-citizen, right?
Well,
It says I'm a citizen.
it
Right.
says I'm a citizen. So we would either, and I think the language is gives a lot of deference to me. I would either use the same form and just, if they leave that blank, reassure, with them that that was left blank intentionally, or I might just create a whole new form based on it.
Oh, that's right. I forgot. Yeah.
Leaves
Okay.
that off. Probably I would just use the same form, honestly, and just verify with them that they intended to leave that blank, and then those go in a special place.
Because the form now has a thing that says I'm a citizen.
Yeah.
I haven't seen the form in a while. I haven't registered to vote lately, so I don't remember.
So yeah, a couple ways I might do that, but it doesn't.
Okay.
Madam Chair.
hmm
Hi. I'm sorry I was a bit late. John, would it be possible for you to get from US, from whichever department in the United States government would give it to you, a list of all the green card residents living in Montpelier, so you'd have a list so you could just work from that?
I'm not sure. That might be very difficult to get, but again, I would be concerned about creating new bars and new types of verification. We don't, for example, compare when somebody comes in to register to vote. We don't match them against the grand list. We don't match them against any other kind of verifying list. So, I could, but again, I think one of the underlying principles under this is we're not adding any additional burdens, because that's a slippery slope. If you get that situation, then you could step back and say, well, for the non-citizens, we're making them go through this extra hurdle. So what's sauce for the goose is sauce for the gander. Why aren't we making other voters go through the same hurdle? And so I think to avoid that kind of argument, it's been very much we're treating them just like other voters in the city.
But other voters are checked. Other voters, you have to put your driver's license, that's checked. There are things that check when you register to vote. It's, you don't just accept.
Oh, I see what you're saying. Okay. Yes, if they obviously they don't have a driver's license or a social security number, technically, we are still allowed to allow people to vote. But if they mail it in, they have to provide some proof of residence. Yeah, under the current system, if they don't get me the proper ID, I still let them vote. That's the rule from on high. Because that oath, it's all about the oath on that form. But I would capture a driver's license if it's available. If it's.
But when I register to vote these days, I don't have to show proof of residency, do I?
Well,
you write it down. You write down your driver's license number or the last four of your social security.
I guess I should look at the form. I haven't looked at the voter registration form in a while.
But ID is not required.
Right.
ID is required in two places. You either have to have a driver's license.
you don't have to show it. You just write it
No,
down.
you don't have to show it.
But that doesn't also, driver's license, writing down my driver's license number or my social security number doesn't tell them that I live on Elm Street in Montpelier.
No,
It just says,
it's true, but that's how you register. I'm sorry, I'm confusing going to vote versus registering to vote.
When you register to vote, you fill out the
clear.
form and it asks you for your address and it asks you for your town of residence, both your mailing address and your town of residence and your either the last four digits of your social security number or your driver's license. And then you take the oath and say that everything I've said here is true. And that's exactly what John is saying he would do for a non-resident. He would just leave off the line that says, "Are you a U.S. citizen?"
Yeah.
And they wouldn't check that, but they would do everything else that a voter who is registering to vote.
Right. And I guess what I was meaning was that you don't have to prove it in a sense. Like, you write it down. You're taking my word for it that I live on Elm Street in Montpelier.
Right.
Because
Right.
you signed that oath.
Right.
That
Right.
says,
I've taken an oath that says it's true.
and
And that's because this stuff goes way back, right?
Right.
And it hasn't been changed over the years simply because there hasn't been a reason to. It's sort of an if it ain't broke, don't fix it kind of idea. I always tell folks, in terms of the access versus fraud balancing act, if you start seeing that balance start to shift, if we start finding evidence of fraud, and this would include at the city level, then obviously we would need to return to the conversation about restrictions. But, just making that oath on that form and we verify to the extent possible hasn't been a problem so far, which is not to say it can't be a problem someday. But at this point, it's not, hasn't been an issue.
so what I'd like to do is switch to Dan Richardson, who, when you came in last year or last biennium and spoke to us and gave us some history about the when we started requiring citizenship to vote, and just gave us some history and some background information on this topic, and would like you to do the same thing for us today, if you would. I don't know if you know all the committee members. I'm Jeanette White from Wyndham.
I'm Anthony, Washington County.
Brian Collmore, Rutland County.
Allison Clarkson, Windsor County.
Keisha Ron, Chittenden County.
Good afternoon, everyone.
Sure, thank you.
I'd be more than happy to walk through. And I did, I think one of the good parts of this process last time around was, Tucker's predecessor, Betsy Ann Rask, did a really excellent job of outlining a lot of the constitutional issues that are involved here. And we had a very good dialogue back and forth. This was mainly in the House. But I'll be happy to walk you through some of the historic precedent. The thing to keep in mind is that when Vermont was initially formed, the idea of citizenship wasn't necessarily codified as a concept, quite the same way as we would perceive it today. And the original Vermont Constitution did not have the citizenship element to it. It did add to that, I believe in 1828, the citizenship requirement. And it is in the Constitution under Section 42 that it requires citizenship as an element of voting. But the distinction that was in place, even at that time, as far as we can see from the case law, is that voting and the freeman status was a state level voting qualification, and that the subdivisions of the state, the municipal corporations, were always seen as different. And that really, one of the cases where that really is illustrated is in, let me just call it up. It's in State versus Marsh, which is from 1789. And it discusses the Vermont Constitution and whether an election at the town level had the same requirements as a state election, because of course town meetings at that point in time were primarily conducted by voice vote. And so there was a challenge to whether the election of a select board member could be done by voice vote or whether it could be done by written ballot, as the Constitution seemed to require for elections. And Chief Justice Chipman for the court wrote that it was not, and he wrote that the framers of the Constitution were forming a plan for the general government of the state. They do not appear to have had an eye to the internal regulation of lesser corporations, which are municipalities. In this section, they point out the mode of electing officers to the general government. And in this view, They confine it to elections by the people and General Assembly. The people here mean the collective body of the people who have a right to vote in such elections, and is used synonymous to freemen. The word election, when the choice is to be by the people or freemen, is in every part of the Constitution used in the same appropriate sense, as in the 7th section, in order that the freemen of the state may enjoy the benefit of elections, as equally may be for each town within the state may hold elections therein. For what purpose? For the choice of choosing representatives in the 10th section, etc. I am therefore clearly of the opinion that the 31st section of the Constitution does not extend to the choice of town officers and is to be laid wholly out of the case under your consideration. So what the court is saying in that respect is that the legislature can set the terms for local elections. And in that case, it was a voice vote, but it also deals with the idea of citizenship. And we have an 1863 case after the Vermont Constitution had required expressly that citizenship be a component of voting qualifications. So there's no question that the Vermont Constitution required for qualification that U.S. citizenship be a component of it. Yet in 1863, we have the Woodcock case, in which an Irish national who was living and owning property here in Vermont was elected, I believe, the delinquent tax collector for the town. He was a resident alien, and he was challenged by whether he could hold office. And in that time, the court upheld his right to vote and hold office because the requirements for this, I believe at that time it was a school district, but it was that the person be 21 years of age, reside in the town, and own property. And because he met those qualifications, he was eligible to vote and hold office. So as of 1863, we have fairly good historic records from the court cases that non-citizens were allowed to vote in these local elections and hold office, and that did not offend the same constitutional structures that are in place now currently that require electors on the state level to be voted into office. That changed subsequent, and really in the latter 19th century and early 20th century, you had a shift away from these requirements of voting that were really more property based as opposed to residence or citizenship based, and we moved away from that. So, for example, we don't require people to own property to vote in elections or pay a poll tax, but we do require them to be citizens. But that's really by statute, and that's a statutory change on the local level. And what we've evolved in Vermont is a system where by statute, any local election carry the same voter qualifications as a statewide or state level office or federal election qualifications. And that's, age of 18 or older, U.S. citizenship, Vermont residency, and taking the freeman's oath as a requirement. And so historically, that's, I want to be clear that that's not anything that was necessarily the historical trend. It's something that did develop. It's been around for a long time. So certainly in any of our lifetimes, these have been the rules. And it did represent a shift away from other requirements for how we determine voter eligibility, such as owning property. And right now, it's a single test. And so what this proposition with this charter change does do is it does create a different classification of voter. It would be the non-citizen voter. So what Betsy Ann, and I don't want to speak for her because obviously she's not here, but what both Peter Teachout, myself, and I believe Ms. Rask, Attorney Rask, came to as a conclusion was, that it was not a violation of the Vermont Constitution to allow local non-citizen voting. And that's also consistent too with the difference that courts have long recognized between state level and local level. And I'll just use by analogy, taxpayer standing. So if I'm upset with the federal government or the state government in the way they're spending some program, say I'm not happy with a weather balloon program that the Atmospheric Institute is running, and I don't like that my tax money is going to that. I can't sue the federal government for that. I couldn't sue the state government for that simply because my tax money is going to that. But if I'm a local resident of a municipality and I don't like, I feel that something, some local tax money or government program is being run against either a constitutional principle. So, for example, I've been involved in litigation where a town was sued for giving money to the historic preservation of a church. And opponents sought to challenge that as a violation of the First Amendment and the separation of church and state. They had standing to bring that case because of local taxpayer standing. The court recognizes it's different on the local level. We're much more closely connected on the local level than we are on the state or federal level. So we have this long tradition of treating local government and municipalities as different. And so what the Constitution mirrors in this particular case is that the legislature sets the rules and they define what a voter is for a local election. And what they have done, we've done this shift where we've gone from a property-based, sort of a stakeholder-based type of voting status to one that's much more sort of unified as based on citizenship and residency. So I'm more than happy to answer any questions. I've laid this out in a couple of memos, and I would certainly recommend to the committee if they really want to dig into this. There's some really excellent law review articles that I cite in my memo. Now Congressional Representative Jamie Raskin actually wrote, this was an area of his scholarship when he was a law professor, and has a couple of really wonderful articles on what this means historically and across the sort of colonies that became states and how that idea of citizenship evolved over time.
Thanks. Any
Sure.
question? And Senator Polina?
It just, excuse me, at the end of what you were saying, Dan, you ended by saying that the legislature sets the rules for local elections.
That's
But
right.
then if you were to go on from it, you would then say that local communities can change those rules or can, in other words,
Well,
it sounds like you're saying it's up to the legislature to define who can vote when you say that.
It is.
It is.
I mean, that's essentially why this is here. I don't think you could create something where a local community could on its own do this. Because we're a Dillon's rule state.
Oh, that's right. It goes back
Any
to that
authority
again, right?
has to come from on high, and this is
Right.
on high.
Right. Okay, I got it.
We are on high, yes.
We're high on ourselves.
And it does, if you look at under the charter, the section 69, it says, and they are to be under the patronage or control of the state, but the General Assembly shall provide by general laws for organizations of all corporations hereafter to be created. All general laws passed pursuant to this section may be altered from time to time or repealed. So
Right.
in this case, we're not doing a general law, we're doing a specific charter change, but we could even change the general law if we wanted to say that in local elections, all non-citizen residents could vote. We could do that.
Right.
You could, and that's really sort of, I think there's really two excellent points embedded in that comment, Senator White, which is, first of all, there was a constitutional question of whether this could be done, and I feel that the scholarship that we've put together has shown that this is outside of the constitutional mandate. So it's really a policy decision by the legislature. And So the ordinance can be changed. You couldn't change it for statewide elections, but you could change it for local. And the other point here is really sort of a larger, and you deal with this every day as this committee. There is a theory that local governments are laboratories. We use this on a federal level to talk about states as laboratories within the federal experiment, but it's really true on a local level. You have a wide array of charters for towns and cities and villages, and they offer different options. And one of the proposals that's embedded in here is that Montpelier is a relatively small community to try this experiment out. And it is an experiment because we haven't done this in Vermont. Other communities throughout the United States have done it. Maryland and I believe Chicago have either done it or are in the process of it. And so, the way we have our government set up and the legislature controlling the local municipalities is that does give you the opportunity to say, well, if we give one community the opportunity to try this, and if it's successful, we can adopt it more broadly. And if it's unsuccessful, then we can quickly fix it. And it's like a contained plague.
So the two objections. Oh, first of all, does anybody have any questions for Dan before I? So the two objections that I've heard most expressed, and if you might want to comment on them, are if non-citizens are allowed to vote, then what is the meaning of citizenship? And the second one is, if we allow non-citizen residents to vote, why would we not then allow non-residents to also vote in local elections? Those are the two concerns that I've heard expressed the most about this.
Sure. Well, I don't think allowing non-citizens to vote at a local level, and to be clear, this is not a slippery slope. This isn't something where if this got really popular, we'd suddenly be able to, people would suddenly be able to move it up to the state or federal level. There's constitutional controls that would require constitutional amendments. And we know how difficult it is to change the Vermont Constitution, let alone the federal one. So it really is a cap. This is a limited place. And citizenship, it's an interesting question because it's an evolving concept. And I would suggest that citizenship on the national level, which is what we're really talking about here, that would continue to have the same meaning that it does today. And local elections are different. We're talking about local communities and how they spend their money on paving streets. We don't, I happen to be now on the City of Montpelier City Council. I can tell you we do not have a foreign policy. We do not have, most of our decisions are really about neighbor to neighbor. I get calls from people saying there are some big potholes in front of my street. Those are the common calls that I get. And that's the business of local government. And so I don't think it would really impact that. The question of citizenship is a really tricky one. And I'll use an example. One of my law partners, his wife is a Japanese citizen, and she has kept her Japanese citizenship, in part because her family lives there. And giving up that citizenship would be significant. And particularly right now, she hasn't seen her family in over 2 years because of the pandemic. And she's going this summer. Now, my partner can't go because right now in Japan, only citizens are allowed entry into the country. So if she had given up her Japanese citizenship, she'd be prevented from seeing her parents, from taking her kids to see their grandparents and aunts and uncles and family members. And so there's a number of personal reasons why people don't convert citizenship from one country to another that really don't have anything to do with how they live or vote or reside. Now, this is a woman who happens to live in Montpelier, has lived here for more than 10 years. She works here. She pays property taxes. She owns a house. She lives here. She sends her kids to the local schools. She is a member of the community in all respects, shapes, and forms that we consider membership in the local Montpelier community. And really, residency in a local community is not as much of a function of citizenship, because it is something where right now under statute, if you're a U.S. citizen and you move to Montpelier, you can become a Montpelier voter the minute you step foot off of the bus or car and arrive in town, under the rules that you've declared your residency. And so, the idea, and given the way society works now, people move around. It's rare for somebody to live in one place or time for an extended period. And that may be driven by family, by jobs, by all kinds of different situations. And so we have a very malleable and permeable sense of what means being a member of your local community. And so, I don't think it changes the concept of citizenship, but it does give voice to members of the community and what on the local level. And I think that's ultimately a very conservative argument for this proposition, which is that, what we're talking about are participants and members of a community having a voice in that community, and directing where they want their money spent or not spent. So as to your second question, it's certainly, as I said before, it's the legislature's prerogative how they choose to define voting on the local level. But I would suggest that it's a very different proposition when you talk about non-residents who just happen to own property, because now you're making ownership a component of voting, which we've moved away from. And you also would have the result where somebody would have effectively two residences. They'd have their primary residence, and they'd have the local voting rights in the community where they happen to own property, which is, I think, a very different philosophical conception. And I should say I've actually litigated voting roll cases in various communities, and we had a town where there were people that owned property, and they lived in Connecticut, and it was pretty clear that was where they were employed, that's their primary residence, where they spent most of their time. But they registered to vote up in this Northeast Kingdom town because it was, in some ways, it was a wonderful thing, because it was such a small community that they're bringing their family up to vote made them a huge voting bloc, and they were power brokers in this town. And so, we had to remove them from the voting rolls, and it went to litigation because they did not establish their residency up here. And while they owned property, they really were, there's a difference and a distinction between where somebody chooses to make their residence and defining voting rights on the local level based on residency, as opposed to just mere ownership. And the fact of the matter was, if these people want to go on the voting rolls, they can in the future. And that was actually part of their argument, is someday we do plan to make this our primary residence, which the court said, that's great, that's wonderful, but today it is not. And therefore, you're not allowed on the voting rolls. And then they were removed. And it was defined because while they owned, they weren't participants in the community in the same level as a primary resident and one primary residency.
But that was helpful. I mean, I think the same thing, but I just wanted to hear you say it.
Sure.
That was John.
I just wanted to echo that non-citizen voting is distinct from non-resident voting. I mean, they're connected in as much as they're all about voting, but that means, non-resident voting is just as related to the 18-year-old limit or the oath. I mean, yes, they're all under voting, but they are very, very distinct issues that I think it would make sense for the legislature to take up separately from each other, the same way you would take up any other separate things. And as far as the citizenship thing goes, I do think there's a sort of implicit statement that comes from the Montpelier community that we do implicitly, informally consider these folks who we want to bring into our voting process to be citizens of the community. And I don't think there's any contradiction there any more than, I can be a citizen of the US without being a citizen of North Dakota. Those things aren't quite that linear. And again, we're talking informally here, but I think that's the concept that the Montpelierites want.
Senator Clarkson?
Dan, isn't there a national, I feel like there is a law that says you can only vote in one place. You're not allowed to vote. You need to vote where your primary residence is. Isn't that a national law?
It is for either state or federal elections. But if you think about that law doesn't extend to local communities. And that's really about the qualification for voters for voting, which is, you can't vote twice in a national election. You couldn't say vote for president in Connecticut and then again in Vermont in the same election. That's against the law. Just as you couldn't vote for governor from Sharon and from Burlington. You can't vote twice in that same election. But these are separate elections. So there's no law saying you can't vote in Montpelier in their local, town, city election, and then go vote in Boston, Massachusetts in their local town election, because they're disconnected and unrelated elections.
So the primary resident issue is a tax issue? Because we think of you can only vote where your primary resident, in your primary residency. So are you saying that's a tax overlay on voting policy?
It is not. Primary residency is a bit more complicated than that. And the Vermont Supreme Court has been a bit reluctant to define it. It has two components. There's an objective component and there's a subjective component. The subjective component is basically the voter saying, this is my primary residency. I have no others. I live here. And it's something they can, as I said, historically, there used to be times you had to live in Vermont for so long before you could make that declaration, a year, 6 months. That's been removed so that the minute you move to the state or to the community, you can declare yourself a resident on a subjective basis. The objective component basically talks about some indicia that backs that up. Like I can't stand in North Dakota and say, I'm a Vermont resident, never having touched the state, but mentally I'm in Vermont all the time. That won't work. You have to have objective standards. And within that, there are really two types of tests that I think are evolving in the court system. One is, how do you create that residency? And the other is how you maintain it. And I think it's important to think about that in separate ways. So to create it, you would have to take affirmative steps. And oftentimes it's creating an address. If you are voting in Montpelier, you have to have an address for your voter registration. Now, if you're homeless and you're voting, you're going to have to show other indicia that you are not only intending to be this your primary residence, but also, what have you done? What steps have you taken? And to go back, I think the conversation before I joined in, these are all done under the penalty of perjury. So, they can be tested and challenged, and people can be removed from voting rolls if the objective indicia are not satisfactory. And, so things like tax, is this your primary residence for tax purposes? Those are generally indicia that are used. Once you form that residence, once you sign that lease, once you move to the state, effectively, those all become elements. But there's not one. The Supreme Court hasn't said this is the one test for residency on the objective standard. They've always said it's a very fact specific. And when they've looked at it from the other side, from people, when they leave a community, that's led to a couple of interesting cases. And that's actually a bit harder. It's harder to lose your primary residency than I would say it is to gain it. In that you have people that leave the state for example, my spouse is living in California this year in a postgraduate program. She hasn't lost her Vermont residency because she still owns our house. She still pays her taxes here. She still, she has an intent to return. Her absence is temporary. It's a defined temporary absence. And even if this graduate program was sort of endless, the fact that she continues to see Vermont as her primary residence means that she continues to be a Vermont resident for purposes of voting. Obviously, if you enroll and say, my primary residence is somewhere else, that's evidence that you no longer have that subjective intent to make that your primary residence. And then if you've taken steps such as moving out of state, that couples with that. But that's a slightly different test. But they're all very fact-specific indicia to determine. And in part, the way the statutes is set up is if somebody makes that averment under oath and is challenged, the BCA hears that challenge and does a fact-specific hearing in which persons can bring evidence forward why this person isn't a resident or bring evidence forward in support of that residency.
Thanks. That's interesting and helpful.
Tucker, did you?
Yeah, it tickled my mind when you all were talking about whether or not non-residents could vote. I think that there are a few municipalities with specific municipal boards where non-residents can vote, and those are the municipal enterprises, water and sewer and electric utility districts. For some of them, and I just looked up the charter for Northfield, the commissioners of those boards are elected by ratepayers, not by voters, but specifically by those that are paying the rates for the utility they're receiving. So theoretically, and I don't know if this is the practice in any of those communities, but a non-resident who qualifies as a ratepayer on that system could vote for those elected offices.
But not for the select board, because
Correct.
presumably there aren't ratepayers for select board people.
Right.
I don't think too many select boards get pay from their constituents in the terms of rate. It would be nice, huh?
No, but they do get paid.
Well, they get paid, but they get paid out of the town budget, not out from ratepayers.
Correct.
Yes, I guess if you.
That is interesting. Thanks, Tucker. That's any other questions or comments or concerns or
No, it just passed on the House floor, I think, yesterday, right? The Winooski Charter. So this is, it's coming at us again. More towns may be interested in extending this, right? And after we've done it once, we could extend it to, as Dan said, I mean, we have it in our authority to extend it to every locale.
by changing the general statutes.
Yep.
But on the other hand, I want us not to forget the fact that we didn't bring this to the floor last year because we didn't have the votes to pass it
Right.
in the Senate. So it's not easy as it sounds.
Right.
And I'm wondering, I'm not saying you guys would know this necessarily, but I'm wondering what kind of arguments were made against it on the floor of the House. I don't know if you paid attention to the floor debate or not.
No, but the nice thing about our life now is you can go and watch it.
Oh, thank you. I'd rather have somebody recap it for me if they wanted to. I don't know if anybody from Montpelier watched the debate on the floor for either Montpelier or Winooski, and if you had any, what the concerns were. Dan?
I'll only offer this, and I did not watch the floor debate, but I have, in discussions, I think the concept of citizenship is often the thorn. And I'll be honest, I first dealt with this when I was representing, where I was working with some city councilors in Burlington when this issue came up as a proposal. This had to have been eight or more years ago. And I was hostile to it at first because I think there's a certain presumption of, well, this is a function of citizenship, and we divide the people that have a voice in government between the citizens and non-citizens. It wasn't until I dove deeper into this concept and started to parse it apart. And what I came to is I'm a merit badge counselor for the Scouts. And when you're in Scouts, when you're working through your Eagle badge, you have 3 citizenship badges you have to earn: citizenship in the world, citizenship in the nation, and citizenship in the community. And I think that's a really helpful framework, because I think we mix the concept of citizenship in the nation with citizenship in the community, and they are different.
That is a helpful way of looking at it.
I have to tell you that when I first heard this, I felt the same way. I said, no way, Jose, no way. But I've learned more by, as Senator Sears said, by listening. Senator Polina, you had a...
I was just going to say that the argument, the argument we heard from people in our caucus last year was that voting was a privilege of citizenship, and it's something that you don't give away lightly. You don't if people want to vote, they should become citizens. It's a privilege to vote, and it should only be retained by citizens. That's the argument people were making in the caucus.
So Dan, can you remind me, I believe that when the US Constitution required citizenship it was around the same time that we started having a lot of Irish immigrants. And am I right about that? When there was kind of
the first influx,
the movement against immigrants?
Right. It was part of, if you think about, I don't think the founders would have had the same concept of citizenship that we articulate now,
right?
Because a lot of them weren't, they weren't natural born citizens. They weren't, they created the idea of this country. And so, you only have that sort of first wave of immigrants, and they were primarily from Ireland, that people start to codify the difference between those who've been here and those who have just come. And of course, you have a lot of the pushes to change the requirements for voting coming during different periods of time. The Chinese immigration in the latter 19th century out west, the early 20th century, particularly around World War I, with the fear about Germans and Japanese that were driving these sort of pro-citizen pushes in the legislation, and these are in part reflective of it. It's not the only reason. I think there's sensible reasons why we create citizenship and create these distinctions, and in part that's what informs people the concern. And I would echo the caucus's sentiment. Voting, the franchise of voting, is a serious thing, and when you think of expanding it, you should do so thoughtfully. And I think that's what certainly led me along this path to say, to come from a skeptic to someone who believes that this is a good thing and a good policy, because of the different standards that are employed here.
Oh, John, sorry.
Yeah, I just want to add into that and follow up with the comments Senator Polina said, although I do tend to bristle at the idea of voting as a privilege personally. I think it's a basic expectation rather than something granted from on high, which privilege implies. But let's start from but assume that it is. I think it's absolutely right. Voting is a privilege for citizens of the country. They have that privilege. Voting is a privilege for citizens of the state. They have that privilege. What the community of Montpelier is saying is that they want to extend that privilege in that context to people we consider citizens of our community. So we're not speaking to the privilege of citizenry to the state or the US. We're talking about the privilege of citizenry to Montpelier. And so I think it's a completely consistent approach.
And may I, Madam?
Yep.
Dan, was it 1828? The citizenship became a requirement. Is that what I wrote down correctly? Was required as an element of voting?
Yes, at least in the Vermont Constitution. U.S. citizenship was added to the Vermont Constitution as a voting requirement in 1828.
And when was it added nationally? Just before that?
I believe so, although I don't have that information in front of me. So I'm.
It does parallel with the potato famine, as I recall. I mean, with the huge first exodus out of Ireland.
Right.
No, it's
Right.
and I just to go to John's and the privilege. What's a right and what's a privilege? And it's an interesting balance here because one that's a policy and philosophical difference, I think, as we think of it, something as a right or a privilege. And how much prejudice and the human gut wiring. I mean, it's so bizarre that we're so wired for the clan, for we, they. It's just always amazes me how much prejudice plays into our laws. Never ceases to amaze me.
Senator Clarkson, I'd suggest going back to some of the research and memos that Betsy and Dan and others produced about the timeline of voting in the United States in federal elections. And the reason that it's fairly complicated to track from at least the time that the Vermont Constitution incorporated citizenship as a requirement is that it went state by state until federal law was amended requiring citizenship. And perhaps the last state changed in the 70s or 80s, and then federal law was amended, I think, in the 90s. But you should go back and look at the timeline of events because it's, from what I recall, it's fairly recent.
1880s and 90s. If it started in the 1820s and it took 60, 70 years to complete.
20th century is what I was talking about. It took 100 years or more for this slow rollout to take place.
Wow. Amazing. Oh,
And-
thank you, sweetie. Ooh,
And that's actually still reflected in federal law. I know one question that came up is, if we allow this, will it cause problems with federal law? And, non-citizens who vote in local elections, would that impinge upon their ability to seek citizenship, or would they be in violation of federal law? And 18 USC section 611, which is the relevant statute, actually allows for this type of voting, and says that it is not a violation of federal law for a non-citizen to vote in a local election where the either state legislature or the local ordinance allows for such.
Have we lost our chair somewhere, didn't we?
Yeah, she
vanished.
just disappeared.
Yeah, she just vanished off the Zoom.
She
Well,
got sucked back into history.
you want to just go see? Want to go see if she's out in the hallway?
Yeah, I'm going to go check and see if she's gone to a probes to get us more money for something. Mr. Vice Chair, may I ask?
Sure. I just want to say that also, that's fine, Senator Clarkson, ask your question, but we're going to wrap this up in just a minute or two because we have to move on to another topic at 2:00.
You are so good. I guess my favor is to Gail and Tucker. If we could refresh all those documents and put them currently on the page, on our page, for people who are wanting to, so that we can send people to those documents that are current, without them having to go back 2 years or a year. Yeah, it was 2019 we discussed this last, I think. Right? We could refresh it and have everything on our webpage now. That would be great.
Yeah, I was going to make the same request, actually. I appreciate that.
Great minds.
You bet.
And you're in the square next to me on my computer.
I'm up here.
I know.
Well, okay. Well, I'm sure we'll spend some more time talking about this another time, but I think we should move on. Thank you, John, and thank you, Dan, for joining us and all your expertise and knowledge. It's really, really helpful. Because I just would remind us that this was not an easy thing to do back in 2019 or whenever it was we brought it
Yeah,
up. And
it wasn't.
to talk about privilege and citizenship, you should have been in the caucus meetings we had. You would have enjoyed being a fly on the wall there, believe me.
And may I speak to John on a point of personal privilege? It is always a joy to live in this small state where I just spent the previous hour with your wife in the women's caucus, and then to come into this, it's great. You know, I was like, oh, I've got the whole family. Now I just need the boys.
That's right. Well, you can invite, them to testify too. They're full of wisdom.
Oh, I'm sure.
Thank you guys for being here. Appreciate it.
All right. Thank you very much, Senators.
Thank you. Welcome back to Senate Government Operations. It is still Friday, April 2nd, and we're going to spend some time discussing H-135, which is a draft of a bill to deal with some changes to the Vermont Ethics Commission. It's not the Code of Ethics itself, but it's more the operations of the commission. Larry Novins from the Ethics Commission is here with us, and Amber Abajali is going to go through the bill with us from Legislative Council. So Amber, you want to walk us through the bill, draft 1.4?
Yes. So as you may recall, about 2 weeks ago, I did a walkthrough of H-135 as passed by the House. There were 3 changes that the committee requested. As you'll see, there was a variety of, just as a refresher, these are changes to the State Ethics Commission statutory provisions under Chapter 31 of Title III. This, as the Vice Chair mentioned, does not include any of the proposed State Code of Ethics language. This is simply about the operation of the State Ethics Commission. So the version that you're seeing right now is a strike all amendment to H-135 as passed by the House. However, the only changes from the as passed by the House version are the changes that are highlighted in yellow in draft 1.4. So I will walk you through those. So beginning in section 1, section 1211, executive officers annual disclosure. You may recall there was a conversation and a concern about using the phrase the previous calendar year, as for some executive officers who are appointed mid-year may not understand that the request is for the previous 12 months and might think that the request is for a January to December. And so the request was to make a change by striking calendar year and putting in 12 months instead. Mr. Vice Chair, should I pause for any questions or comments after each revision?
I would pause just very, very briefly because these are pretty basic changes.
Okay. All right.
If anybody has questions, chime in when we're there.
Okay. So the next change is all the way down on page 11, I believe. And this is the section where the committee spent a fair amount of time hearing testimony and discussing the provision of guidance and issuance of advisory opinions to individuals that are or will be subject to this chapter. There was a concern, as I understand it, about the language within H-135 as passed by the House that someone could, either a future executive director or future commission members, could interpret subsection A1 as permitting the commission or the executive director to provide guidance to either someone other than someone who is or will be subject to the provisions of this chapter, or that the commission could proactively provide guidance even if someone does not ask for it, or on a subject matter that doesn't relate to that person's specific duties. And that concern was also raised with regard to subdivision B on page 12 regarding advisory opinions. There was, if I recall, a little bit of confusion and then clarification about what is an advisory opinion, what is guidance. Guidance is the document that is issued to a specific person about their duties. The advisory opinions are those the issuance of an advisory opinion that is then later posted to the state Ethics Commission's website. So just as some background there.
No, you're right. You're right. We were definitely confused about that. I think some of us thought the opposite was true. That we thought that guidance was an advisory opinion, and advisory opinion was guidance. So we were definitely, we were confused, or we were still learning which was which.
Yes, and myself included in that. So that was a very helpful clarification during the discussion. So the request from the committee was that I insert the word only around the guidance piece, so that the executive director may provide guidance only to a person who is or will be subject to the provisions of this chapter upon his or her request with respect to that person's duties regarding any provision of this chapter or regarding any other issue related to governmental ethics. For the advisory opinions down in subsection B, after reviewing the language in here as written, which is on the written request of a person who is or will be subject to the provisions of this subchapter, the executive director may issue an advisory opinion to that person that provides general advice or interpretation with respect to that person's duties, etc. And I believe the committee felt that that language was a little more specific perhaps than in subsection A and did not need the word only. So I wanted to provide an alternative option for the committee to address what I believe is the concern, which is that someone will interpret these sections to say that because the language says the executive director may, someone may interpret that to say, well, it doesn't say I can't provide guidance or issue an advisory opinion to someone else. And so in case the committee found that inserting the word only was not sufficient to address that concern or the possibility of that misinterpretation or misapplication of this provision, I provided you with some alternate language, which is also posted. I will give people a moment to pull that up if they haven't already. Does everyone see the other document that I submitted to Gail? I'm seeing some nods.
Yes, I do. Yeah.
Okay. So this would, instead of inserting the word only, or I suppose you could, in addition to inserting the word only, provide a new subsection C, which states the executive director shall not provide guidance or issue advisory opinions in circumstances other than those specified in that section. And I felt that sort of encapsulated what the intent was that the committee was looking for, but the committee did request that I use the word only in that subsection A. So that is how I did the initial draft. I did talk through this language with Executive Director Novins. Am I saying your last name correctly, Larry?
Novins.
Novins. Okay, thank you. I'm glad I asked. With Director Novins, he had some concerns about using the word or having the word only in there as it's placed. I won't get into those because I think he would probably explain his concerns much better than I can. And he also had some concerns about the alternate language that I proposed. But this is I wanted to give you what you requested, which is the only put into that subsection A, and then an alternative that I thought might also address the concerns that were raised by the committee, the last section.
Okay. Well, maybe we should ask Larry what he's thinking. Larry, what's your response?
Well, let me go through them one by one, if I may.
Sure.
The first change to 1211, the 12 months, we're fine with that. And then, well, we haven't gotten to the change about the hiring position, but we're okay with that as well. With regard to this section, I think the language, the quote, alternative or alternate language is going to create some problems for us. And I think the problem that I see is it sounds unduly restrictive. We have a duty when we get calls, people call us and they ask us about ethics things, and it may or may not fall within the bailiwick of the Ethics Commission. You know, if I get a call from somebody, a municipality or something else, and they call me and say, what do I do? Where can I go? And I can sort of point them in the right direction. And I'm worried that the language, that the only guidance I could ever give would be limited to those specified in the chapter, would make that very confusing and deter people from contacting us. My thought is that section B on advisory opinions is clear. That if, however, you wanted to put an only in there, you could put an only at the very beginning. So that B1 might say only on the written request of a person who is or will be subject to the provisions of this chapter. That would take care of your concerns. I've thought from the beginning that it was clear and it didn't need any extra clarification. But if you feel that it does, I would recommend just putting the word only at the beginning, not at the end. I don't think there's a risk of the executive director issuing a guidance or an advisory opinion to someone else just because it says may. The way I read the statute, and I think this is consistent with normal statutory interpretation, is the Ethics Commission has only the authority that you've given us. And if you give the executive director authority to issue advisory opinions to people within state government, that's the only authority I have. I don't have authority to issue an advisory opinion to anyone outside. So in my mind, it's clear already. If you need to double underline it, double underscore it, and want to put an only at the beginning of section B, I don't think it's necessary, but I don't think it harms us. What I am concerned about is that the quote alternative language would deter people from contacting us. It would make it more difficult for me to assist other people. If I get a call from somebody and they say, well, I have a question about something that relates to me in my town, or I'm on a board for the state and I've got this issue. I feel that I would be hampered in my ability to say, well, you know what, you might want to go talk to legislative council, or you might want to read the governor's executive order, or you might want to go someplace else to look for resources. And that language about under circumstances other than those specified in this section, I think is really, really restrictive and not necessary.
Senator Clarkson, I have a quick clarification first before you're talking. What only appears in section A under the guidance. That's where Ameren put only, and now you're saying to put it in addition to put it in.
No, I don't think it's necessary at all. But if for some reason you felt you had to, double underline it, then that would be the place to put the word. I don't believe it's necessary.
But you're saying, I'm just trying to be clear. You don't think it's necessary in either way. I'm saying, I'm presenting that it might be necessary in both places.
I don't think, well, let me talk about the advisory opinion first, because I don't have an issue with the guidance. The thing about the advisory opinion is the only way somebody can get one is to write to us, to put it in writing. And it's clear under section B that the written request has to come from a person who is or will be subject to the provisions of the code. So that's very limiting language. Guidance doesn't have that kind of limiting language. Anybody can call me and ask me for guidance. But in terms of issuing an advisory opinion, the only way I can ever do that is if I get it in writing from someone who is or will be subject to the provisions of the ethics code. So I think it's very clear and very limited already.
Senator Clarkson, I didn't mean to interrupt you before.
I'm sorry?
Senator Clarkson. I interrupted her before.
No, you didn't. You didn't. I just had a question, which is, first of all, I think I wouldn't want to do anything to limit your ability to be a resource to a town, to whomever was wanting to seek guidance from the Ethics Commission. So I wouldn't want to do anything here that limited your ability to give that. And I can't remember how we ever got into the only discussion. Why are we, if Larry is recommending that we do nothing to change it, why are we bothering?
I think Senator Collmore remembers.
You're hoping anyway. I think I do. And I still have an issue. So let me open H135, the 4.1 draft. So line 10, on the written request of a person who is or will be subject to the provisions of the chapter, the executive director, et cetera, may issue an advisory opinion to that person. But it doesn't say that you can't issue it to somebody else. And I think that was the original problem that we foresaw, we understand that only by someone asking for it is that trigger to issue the guide or the advisory opinion, but it doesn't limit you from issuing it to anyone besides that person. At least the way I'm reading that, Larry.
Yeah, can I respond to that?
Sure.
The original language of the statute, and this is where I think the Ethics Commission got off the rails, is there was no limitation on who could ask for and receive an advisory opinion. It was our suggestion after we modified our own policies to make that limitation very clear. So we added the language, the limiting language, opinion to that person. We added the language with respect to that person's duties to make it very clear that this is not available to anyone else other than individuals asking about themselves. And that was the whole purpose for bringing that in. I mean, we could have just left it blank and not addressed the issue, but after the debacle regarding the advisory opinion, it certainly seemed to the Ethics Commission that our policy needed to be changed, and we made that change. And then we thought it would be best to mirror that policy change in the statute to make it clear to everyone else that that limitation is not only our choice, but that we have your confirmation on it. So that was the reason for doing that. And I don't think by any stretch of the imagination, it leaves open any ability to grant an advisory opinion to someone else. I don't. Again, we have limited authority. We have only what you give us. And if you give us authority to issue an advisory opinion to the person who asks for it about their conduct, that's the end of it. And we can't go anywhere else.
So if you're convinced that that sentence means opinion to that person and that in fact makes it exclusionary, I guess I'm okay with it.
Oh, I'm absolutely confident of it. And that's why we suggested that language, to make it very clear to the world that the kind of thing that happened 2.5 years ago won't happen again.
Understood. Okay. And I guess I would ask Cameron if, well, you're the well, Larry's the lawyer too. I'm just trying to make it as tight as possible so that nobody else can get it. But Larry is seemingly convinced that that phrase makes it exclusionary, that only that person may be, the recipient of the advisory opinion. And if you're okay with that, Amron, I am too.
Before Amron speaks, I thought that advisory opinions were going to be posted.
They would be, yes.
So they're basically available to everybody.
No, anybody can read them, but nobody can ask for one.
Okay.
That's the difference. They are public records, but if Senator Polina, if you were to ask me for advisory opinion as opposed to guidance, we would issue a written document that would be directed, it would answer your question. Anyone else could see what we said.
Yeah.
Okay.
So Amron, are we okay?
Thank you. So Larry and I had much conversation about these two sections and how they would be interpreted. And so I want to say I agree with Director Novins that that statutory interpretation for these sections where the legislature is granting authorization for the commission to perform an action, that means that the legislature is only authorizing that action and is not and that people should not be interpreting this as you say you may do something, but you don't say I can't do something. So that means I can do the thing that you didn't even mention. I think that is standard statutory interpretation. However, my understanding from the committee was that, as Director Novins put it, there may be some interest in sort of a double underline, right? Given the history of what has happened with advisory opinions in the past. I think that it's really up to the committee to determine whether they think this will be misinterpreted in a way that it has been in the past, with language that certainly was less specific than it is now in its revised version. So, and I believe Senator White pointed out last time, over time, you will have different executive directors, you will have different commission members. And so I think it's really a question for the committee, whether you feel like a double underline is necessary. I think Director Novins is correct that from a statutory interpretation perspective, the language as is sufficient, but it's whether you want the double underline and how you want to do that.
Senator Collmore, Senator Collmore and then Senator Clarkson.
Thank you, Senator. So I guess if I could use the oft-used expression, belts and suspenders, is that what you're suggesting here? And if it is, I guess I'm fine, but Larry has made me feel a lot better. And I'll just say, I don't have a strong feeling either way. If we want to begin that sentence with the word only, I guess I'm fine. But if it's no more than belts and suspenders, then maybe we don't need to.
Senator Clarkson?
I'd leave it as it is. I think Larry's given me confidence that it's fine the way it's written now, and I think I'm going to channel my inner Frank Lloyd Wright. Less is more.
Senator Rahm, do you ever thought about this at all? I don't mean to put you on the spot.
Yeah, no, I mean, I think overall, between the lines, I would say it's better not to give people the false impression that we're doing a whole lot in this area if it's not warranted or needed. I don't want to, if we're not really debating a substantive change to our ethics code,
Right.
and it's a lot to act like we are on the floor, sort of bring it to people's attention in that way.
Well, I kind of feel the same way that Senator Collmore said, and others, that if it's not necessary, then we probably should not bother doing it. I agree with what you said originally, Larry, that the alternative language, with all due respect to Amron, that did seem kind of tight. That alternative language seemed limiting. I don't have a strong feeling about the only. I have nothing against putting the only there, but if others don't think it's necessary, then I would say not to. Are we saying not to put it in either one? Not to put it in the guidance or the...
Just the second one.
Right. Keep it in the guidance.
Yeah.
Okay.
It's
Cameron, is that okay?
I'm sorry.
No, go ahead.
Yes, I was going to say, I'm sorry. Who's going ahead?
Well, Larry, what's up?
Thank you. The difference, guidance only to the person. Guidance is confidential anyway.
Right.
I don't think, again, I didn't feel the only was necessary. I don't think it hurts at all. If I may echo your concern, Senator Polina, a little bit, I think the fewer changes there are to this bill, the fewer problems there'll be down the road. And I'd like to keep it as close to what the House sent over as possible.
True. Amron, did you have something?
I just wanted to add that I'm fine in whichever direction the committee would like to go. I think adding bootstraps is fine. I think the language as it is sufficient from a technical perspective. If you're not worried there's going to be someone vastly misinterpreting it, which it seems like with all of the revisions that Director Novins has requested from the beginning have made the language much tighter. So I just wanted to be clear that I don't really have any preference in this area. I just wanted to provide the committee with what they were requesting after our last discussion. So I am happy to go in whichever direction you would like.
Well, let's go in keeping it in the guidance, but not putting it in the advisory opinion.
Yeah. Let's
And are there other things we need to do in terms of going through the bill then, Amron, or is that basically it?
There's one last change at the bottom. This was the language around adding a position. Let me scroll back here. This is down on page 15 with a new section 4, creation of position within the State Ethics Commission, the Executive Director, with the consent of the State Ethics Commission, is authorized to establish one new part-time exempt administrative assistant position for the efficient administration of the commission. And I will say I drafted this language with the understanding that there does not need to be an appropriation for this fiscal year or for fiscal year 2022. So there is no language in here surrounding funding for the position. This would only create a position or authorize the creation of a position.
Why is that? Why do we not have to appropriate any money for it?
Because he hasn't.
Larry?
Yeah, because during the first year and a half, the Ethics Commission's existence, they had extra money, which is sitting in a reserve fund. And I think it's
Okay.
$57,000 or $60,000 sitting in this reserve fund that we still have access to. And that's why we're not asking and don't need an appropriation at this time.
Okay. Of course, some naysayers will say, well, you're going to come back and ask us for the money next year. Well,
Well,
we can deal with that next year. Senator Clarkson?
kick it down the road, but if we fund the position and have the position and fill it, then for FY 2023, we would be asking for that extra money. Yes.
Sure.
So my only concern is part-time. Do you want a half-time person, a three-quarters time person, a quarter-time person? Part-time is very vague. Do you want a half-time person? I would say it.
I'd be fine with halftime.
Well, then I'd be specific about what you want, because we're good at trying to get what you need and want.
Yeah.
So,
Let's say halftime then. I'm perfectly happy with
it
that.
says part-time, and that could be a quarter-time person.
Right. Well, I mean, I don't know if it'd be possible to do it on less than halftime,
Well,
but
so
I'd say no more than halftime.
Okay, then I would say a 0.5 FTE. You know, I don't you guys agree? I mean, if you say
Yeah, no, I think that sounds good. And the House version obviously didn't have anything and didn't have this in it at all.
Correct. It had very vague language that the House Appropriations Committee took out at the end of the session after it left House Government Operations.
Okay.
I'm fine
Amber,
with it.
you can make that change, Amber?
Yes.
So we're okay with this?
Yep.
I think we're fine with the technical pieces.
Right. I honestly think we should put off the discussion of the code of ethics itself until the chair is here. We can all have the conversation together. Does that make sense to people? I mean, I'd be flexible, but it just makes sense to me to wait for everybody to be here.
No,
It's a pretty broad conversation.
and it's her baby. She'd want it. I mean, this is, yes. I tried her again, and the phone, I think they have lost power. I mean, the phone is still wacky.
Larry, is it sort of a job for you to rejoin us at another time, or?
As long as I know enough in advance to be here, I can be here.
Okay.
So if she showed up in 20 minutes and somebody wanted to give me a call, I would be happy to come back. But
More
if not,
likely be next week or the week after.
fine, just let me know.
Yeah,
Okay.
exactly. It's not like it was a quick power outage. It doesn't look like it. Looks like it's enduring.
Right.
Yeah, I don't think it'll be today.
Well, Larry, thanks a lot for being with us. Appreciate
Thank
it.
you
We'll
all
be
very
back
much.
in touch.
Yeah, if I could just say,
We'll finish up this bill soon and get it out, and then we'll do the code of ethics sometime in the near future.
great. I'll look
We're
forward
not
to it.
privy to the schedule right now, but we can come. We'll be back in touch soon.
Great. Thank you very much.
Thank you, Larry.
Bye-bye.
And we could, as by way of some homework, we should all take a read of 384, which Gannon introduced, but they didn't take up.
That's the code of ethics. Yeah, I skimmed that this morning. And they just decided not to take it up, Ameren, right? They just decided to send it to us. It's like, I mean, there was no particular political reason why they didn't do it, right?
I don't know why, to be honest. I mean, I don't know why.
Okay.
By the time they were busy with things, and then there was pensions, and it's been pensions ever since.
Right,
So
right.
I'm not really sure as to the reasoning.
Okay.
And this is strictly a policy one, and it has made crossover anyway, right?
Right. It might,
we can
even if
work
you
on
hadn't wait.
I mean, 135 is made crossover. So we have one.
Oh, yes, 135 has, yes.
We could
Yeah.
put it on that.
It could be a vehicle for this.
Okay.
I don't think it's dead in the water. I mean, I think we
No,
have.
I don't think so either.
Yeah.
I think it could also be seen as something that we work on this year and come back and finish it up next session.
We could, yep.
Because it might be a big lift. We don't know how debatable it's going to be. People are going to be agreeable or not.
But 135, if we want Larry is halftime person, we need to move on that.
Right.